Welcome to Chapter 9 of the Information and Communication Technology curriculum at Universiti Utara Malaysia. In this lecture, developed by Dr. Ala Jabar Al-Maliki, we are examining intellectual property rights within the digital economy. Consider a common scenario. You spend months developing a highly effective cybersecurity algorithm. You deploy it, and within hours, a rival firm has scraped the underlying logic, recompiled it, and released it under their own name. This illustrates the problem with relying solely on standard copyright. A single layer of protection is easily bypassed when digital products can be replicated and sent across the globe in seconds. Copyright alone cannot protect the underlying mechanics of how your software operates. To survive this level of global competition, developers must look beyond copyright. Protecting a digital asset requires a four-pillar toolkit designed to secure innovation from multiple angles. This brings us to the first pillar, the patent. A patent grants exclusive use of an invention for a limited time, provided it meets three legal requirements. It must be novel, involve a non-obvious inventive step, and have clear industrial applicability. In an ICT context, this applies to tools like a new encryption algorithm. If the math behind your code is truly new and useful, the government grants you a temporary monopoly on using that specific logic. However, patents involve a significant trade-off. The application process is often expensive and time-consuming, and once the patent is granted, your methods are made public, making them difficult to enforce in every global market. The second pillar, trademarks, focuses on brand identity rather than the technology itself. This covers the names, logos, and symbols that allow customers to distinguish your software from a competitor's. Without these protections, bad actors can use similar brand names to create fake websites or domain names. This leads to user confusion and can facilitate fraud. These two pillars serve different needs. Patents protect the way a technology works, while trademarks protect the reputation and identity of the company that built it. Our third pillar is industrial design. This moves away from the underlying code and focuses on the visual appearance of a product, specifically the layout of a user interface or the physical shape of a device. A unique design can increase a product's market value, but it is also a target for imitation. Because a UI is public-facing, competitors can often duplicate the look and feel of an app with only minor changes. When a creator chooses not to disclose their methods publicly, they turn to the fourth pillar, trade secrets. This covers confidential business information that provides a competitive edge. In ICT, this often includes proprietary source code or company databases. Unlike patents, there is no registration required and no expiration date, as long as the information remains a secret. The weakness of this pillar is its fragility. If a data leak occurs or an employee shares the information with a competitor, the legal protection is lost instantly. Once the secret is out, it can no longer be protected as a trade secret. This leaves creators with a choice. They must decide between the guaranteed public legal protection of a patent or the indefinite but high-risk confidentiality of a trade secret. Think about the software you use daily. Consider whether its value comes from a unique interface that should be protected by design laws or a hidden algorithm that relies on total secrecy to remain valuable. This matrix maps the four pillars to their ICT roles: patents for algorithms, trademarks for the brand, industrial design for UI, and trade secrets for databases. In practice, they are rarely used alone. A single product layers these rights, creating multiple barriers against theft. These legal frameworks provide the tools for protection, but they require active management. As we saw with trade secrets, a legal right can be lost if data is mishandled. Effective IPR protection means combining these laws with technical security and